identified. And I believe that both are approaching the concern. Now, sir, if we look at the form that's currently there, it does indicate quite clearly the name of the witness, an indication that the minister, it is already a regulation 28 which says the minister may make regulations generally to give effect to this act. That's the current wording. The additional wording proposed is that, just to be clear, leader of government business, is that the minister shall may by order amend the schedule. I believe the concern that Senator Tate has identified is that while the minister then is being given that power, the question is when or if that power will be exercised. And while the document or the act then comes into play, the schedule clearly states the form of the order. What we have seen, and I've heard my friend Senator Nichols' presentation, is that especially in the civil courts, there is almost a slavish doctrine in terms of following the forms of the order. If we have an item recognition that it is a question of concern and we can amend, all that is required is for, with a stroke, the removal of the references to name of the witness on the draft that we currently have. I think that would be neat. It wouldn't offend any sensibilities, and it will capture the concerns of Senator Nichols and Senator Tate. I am proposing that the proposed edit, instead of being as wide as is proposed in relation to the minister being able to make orders and regulations, that we actually have the forms there, and the forms simply remove the references to a name of witness. That's all that needs to be done. Just a stroke through the name of witness there. And all the forms that are in the draft. It's just a proposal. We'll see, we'll debate it.
Chair, I've taken some time to consult, and I also want to bring to the attention of the chamber that the policy behind this legislation, I know is late in the day, and I want to draw us to clause 5 of the bill, because the proposal by Senator Boyce or the excision of the form or references to the name will do considerable violence to what policy is in the act. Now, this is a provision that allows both the prosecutor and the defendant to make an application to the court for a witness whose evidence is already before the court in some summary form to be made anonymous. And it gives the court the discretion to determine whether the identity of that witness should be concealed. We are not to take away the power of the trial judge who is hearing the application made on facts that are specific and germane to that particular case in the future, and to create a policy now where, in the court's determination, this is not a situation where the name needs to be anonymous. So that it says here, where an application is made by the prosecutor shall, unless the court directs otherwise, inform the court of the identity of the witness, but is not required to disclose in connection with the application the identity of the witness or any information that might enable the witness to be identified. So that it is the discretion of the court at that stage when the application is being made that is being exercised. What the amendment that I understand Senator Boyce to be trying to make, and the concern of Senator Tate, is the question of anonymity generally. But as I've already said, in the formal sitting, on the second reading, where we adjourn, the process must start somewhere. And if you are saying that no name is to be used in an application, then we are really creating a farce. you're really creating a forest, and you've got to be careful that you're not opening up a situation where defendants, criminal defendants, they start to use this process as a means to create administratively difficult situations for the criminal proceedings to continue or to ensue, so that the decision as to the anonymity of the witness and their being named is made by the judge exercising a discretion sitting in the criminal court, not by Parliament taking it away by means of a form. So if we're gonna not, if we want to go and take out the schedule, then you can't leave it at Section 5, which we already passed. So we have not given proper consideration to the discretion exercised by the court on the process of the application. I think it is outside of the scope of what this act is intended to do. We are not here to make sure that, we're not here to administer this act. That is not the role of the legislature. The executive administers the law, the legislature makes the law. But when it comes to now making forms and getting into the nitty-gritty of what should be contained in a statutory instrument, which is a form used by the public, like it doesn't say we should now determine the form of a town planning application, let us debate it, or the form of advisory license. Statutory instruments of that nature are not debated in Parliament. We learned that long ago. Simple parliamentary practice. So I understand the caution. It is a noble consideration. But when we look at the discretion given to the judge, unless the judge otherwise directs, the legislation will make that a judicial discretion that the judge exercises when the judge hears the particular facts of that individual and specific case. And it is not for us to design forms and to prescribe how the application is to be made, because there is a fear that something untoward will happen to every, any, or even one single witness in a matter. It is for the determination of the trial judge. The application can be nefarious. It can be one as wasting time. It can be one that is abusing the process of the court. All these are considerations that the trial judge is at, sitting there every day, seeing these people working and operating, and understanding the culture and how that system operates. It's not for Parliament to administer this system in its operation. So I don't agree with the amendment proposed to the forms in that way. Thank you, Mr. Chairman.
Mr. Chairman, the proposal was in no way referencing the substantive legislation. It's the form itself, and I indicated that the form itself remain as is, just the reference to name of witness be removed. The current solution of saying the minister can make or shall make regulations assumes that the minister shall or will make it. I believe where my friend is missing the rub of the argument is that, yes, we do not get into subsidiary legislation, but when you pass legislation which says the purpose of this is to protect the identity of a witness, and the form which then goes on the said legislation says this is the identity of the witness, and the legislation does not say what specifics will be taken for the said form to be kept under seal or redacted, it's a valid concern which we can address as a parliament. Simple.
Mr. President, sorry, Mr. Chairman, no, we can go at this all day, and that is why these things are not debated, right? If the application is made to the judge and the judge denies the application, even although the party making the application says that there's merit in making this witness anonymous, what happens? That power is not being exercised by this chamber. That power is exercised by the trial judge hearing the application, having a name and seeing who the person is, understanding what about this person and in these circumstances. And sometimes that might be important. I know them well. They're not going to back down, Mr. Chairman. But the judge is the mediator of this issue as to whether or not the person's identity should be disclosed. So being pernickety about the name on the form is neither here nor there.
On a point of order, if that's
Because
what
the
happens.
judge
On a
has
point of order, Mr. Chairman, nobody am being pernickety.
It is
A
just my
point of
opinion.
committee, a point of whatever it is.
No, but
We're asking a question, we're seeking
Mr.
guidance.
Chairman,
The mere
Chairman,
fact
I
that
don't-
schedule has been put into the
Mr. Chairman,
legislation
Mr.
suggests
Chairman,
that we are to
I'm
consider
on
it, not ignore it. If
Mr.
you don't want to sit down, that's a matter
Mr.
for
Chairman,
you.
I'm on my feet, and I don't understand that any point, any standing order has been breached by me using the word pernickety. It has an ordinary and not offensive meaning. It is not, well, I can't deal with that, but it's not, it means attention to small details. That is what it means. Mr. Chairman, the power is exercisable, and I assure this chamber, the power of whether or not this name is disclosed is a power determined by the judge based on the application. What they're asking for is that no name goes on the application, no name goes on the order. Right? The honorable senators. Huh? Mr. Chairman, with all due respect, right? If Senator Tate wants to speak, I know she doesn't want to raise, but she do it right, but you cannot shout across the chairman like that. That is the difference from the side, but you are incessantly speaking. While I'm speaking, and entertaining me, right? Yeah? Yes, I would like you to do that, right?
Thank you very much, Mr. Chair. I note the concerns that have been raised by all of the honorable senators and the amendment that has been made to respond to those concerns. And that amendment is as follows, that Clause 29 read as titled, Amendment of Schedule, and that the language under that title reads as follows. The minister may, by order, amend the schedule. I beg to move that this do not stand part.
The question is that 29 be amendment of the schedule as follows. The minister may by order amend the schedule. So the question is that parts 4, clauses 28 to 29 as amended do now stand part. Will all those honorable senators in favor,
Mr.
please say
Chairman, but you
aye.
have to put in the 30 though. You gotta put in
So,
the 30.
So, Mr. Chairman, if I may assist, by adding 29 is a consequential renumbering. So 29 will now become 30.
That's what we were just saying. That's what we're saying. That's what I was saying.
Okay, so
So part 4 will now be clauses 28
29
to 30 as amended.
So the new amendment is clause 30, which is the minister may by
No,
order.
29,
29,
that becomes 29 and 29 becomes 30.
right, 29 becomes,
Mr. Chairman, the current 29 will become clause 30. And we're inserting a new 29, which is the amendment of the schedule, which reads, the minister may by order amend the schedule.
so a new 29.
Yes, the new 29 and the existing 29 becomes 30.
So a new 29, which is the amendment which was just read, and then 29 be amended to 30.
Right. So it's
Will
part
all-
4, clauses 28 to 30.
Right.
As
Will,
amended.
will all those honorable senators in favor, please say aye. Aye. Those against, please say no. No. Methinks the ayes have it.
Schedule.
Mr. Chair, I beg to move that the schedule be the schedule to the bill.
The question is that the schedule be the schedule to the bill. These are just forms. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Mr. Chair, I beg to move that you do not report to His Honor the President the passing of one bill in committee.
The question is that I now report to His Honor the President the passing of one bill in committee. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the
Chairman,
ayes have it.
you're reporting that the bill has been amended, so I report the pass. Mr. Chairman? Mr. Chairman, the question would be that we report the passing of one bill with amendment to His Honor, the President.
The question is that I do now report to His Honor the President the passing of one bill with amendments. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported the passing of one bill in committee. Senator Cummings.
Mr. President, I beg to move that this bill not be read a third time.
The question is that this bill be read a third time. Will those honorable senators in favor please say aye? Those against, please say no. Thanks, the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Criminal Proceedings Witness Anonymity Act 2025 as amended.
The question is that this bill do not pass as amended and be cited as the Criminal Proceedings Witness Anonymity Act 2025. Will those honorable senators in favor please say aye? Aye. Those against please say no. Thanks, the ayes have it. This bill is now passed and so cited.
Order number 11, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Firearms Amendment Bill 2025.
Thank you very much, Mr. President. This is a brief amendment. It is quite short, Mr. President, but it addresses a number of things, and I want to first thank some of the honorable members in this chamber who have, in engaging with the Office of the Attorney General and other members of our legal team, have raised some initial concerns that have been reflected in the amendments that I want to begin by introducing to this bill. Mr. President, we have 3 amendments to the bill, and I'm going to frame the bill first, what it is intended to do, what it sets out to accomplish in the first instance, Mr. President, and why the amendments were made after consultation with the honorable members in the public space, but also in this honorable chamber. Mr. President, the first instance that is being navigated is the extension of the definition to include component parts, major component parts specifically, and that is the first amendment that has been made, and we will share the details of that proposed amendment. In the initial draft that went through the other place, the definition spoke to component parts generally. In consultation and preparation for it coming to this chamber, there were amendments that were made, and the rationale for that, Mr. President, and I stand and I speak here today, not as a citizen in this context, but as a former chairman of the Bridgetown Port, where we have heard on more than one occasion persons bringing component parts and weapons into the country through the Bridgetown port, and the Barbadian public has been speaking about, well, how are they getting in here? Now, Mr. President, I want to say two things very briefly. One, the criminal, and I'm going to say this repeatedly tonight, the criminal of 1990s, the criminal of the 1980s is not the criminal of the 2000s. I became chairman in September of 2018 of the Bridgetown port, and the criminal of 2018 is not the criminal of 2025. When we came to office, the Bridgetown port had no functioning scanners. There was a discussion, and I remember in this very parliament being summoned as a chairman at the time, to a meeting of the National Security Council where the Prime Minister charged me with responsibility for fixing it. And I remember her saying to me, and I felt as though for weeks after, there were chunks missing from my back for something that I had no part in creating, because she took it very seriously that there were no scanners operating in the Bridgetown port at the time. And she gave me a very clear instruction as chairman: fix it, or we will have some consequences. And so we took the decision to do just that. At the time, we invested several $1 million in installing a fixed portal scanner. That was in 2018. That construction was completed by 2019, because these are not scanners that are sitting in shelves somewhere. They had to be ordered. They came into Barbados. The civil works had to be undertaken in collaboration with the various teams. We had to have radioactive studies to make sure that they were safe. But then something happened, Mr. President. What initially may have started as looking for containers and finished weapons, you then realize that the criminal of 2019 had evolved. They were bringing them in parts, breaking them down, hiding them in smaller components, and then disguising them as other things to then be reassembled here in Barbados. So while we may not have a manufacturing sector, we have an assembly industry here in Barbados for the purpose of trading in illegal weapons. It meant that the scanners in the port then had to evolve to be able to recognize what a component part looked like and what was meant for illicit use. And so this legislation before us focuses on major components of firearm use. It is not meant to criminalize legitimate and legal holders of licenses of firearms, and it is on that basis, Mr. President, that there were amendments made on recommendation from persons in this chamber and beyond. The first amendment, Mr. President, is at Clause 2. The existing Clause 2 is proposed for deletion and is meant to be replaced as follows, and I'm going to read it for the record. That the new Clause B would read, includes any major is a new insertion into the language, any major component part of a weapon referred to in paragraph A, 1, 3, 4, and 5, specifically designed for use in a firearm, including a barrel, slide, frame, hammer, firing pin, auto or automatic sear, trigger, bolt, and magazine, but, end quotations. Close inverted marks. That's the first recommendation that was made and adopted by the government, and so that's the first amendment. Then there's a proposal, Mr. President, for a new clause. A new clause at 3, a new section 504. The Principal Act is now to propose for deletion and to be substituted as follows. 4, a firearm license shall contain permission for the holder to have in his possession ammunition of a type not exceeding an amount specified in the license, and B, such parts or accessories as are reasonably necessary for the repair, maintenance, or use of firearms to which the license applies. Now, this is also an amendment that came post-consultations. As a consequence of those changes, Mr. President, Clause 3 will now be renumbered as the new Clause 4. These are the amendments before this honorable chamber, Mr. President, and with these few words, I beg to move that this bill be read a second time.
Any speakers?
Senator Maynard.
Thank you, Mr. President. Mr. President, I am almost convinced that we have a listening government. A listening government. Mr. President, while these changes to some may look minor, they are indeed major changes. And these changes will remove to a large extent the possible criminalization of licensed firearm holders, which could have happened in the previous iteration of the bill. Mr. President, the government and the police and security services and the customs have had tremendous problems in dealing with the importation of illegal firearms. And as Senator Cummins said earlier, the criminal of probably 1980 is not the criminal of 2025. And people find clever ways of bypassing the restrictions. And with good legal advice, you can be told what is legal and what is not legal, and what you can be charged for and what you cannot be charged for. When this bill becomes an act, this amendment comes into force, it would mean that items which one could have held and not be charged for possession will now become criminal offenses and you can be charged for them. And it's probably the only way to deal with the phenomena that we are experiencing in this country where firearms are being imported in parts and persons are assembling the firearms. And the government intends to bring it to an end. There is the aspect, sir, of the legislation, but the enforcement requires personnel and training and investment. So I hope that having brought the first phase of the process, the government will follow through with the rest of it. I wish, sir, to comment on the second amendment with regard to firearm licenses. This amendment, sir, is an important amendment, and within it, it appears as though the government has acknowledged that whereas in the previous iteration of the Firearms Act, Cap 178, prior to the last amendment in this Parliament, there was only one category of firearm. In the last amendment, we established 3 categories of firearms. And this amendment now clearly indicates that one is entitled to have ammunition on your firearms license. That's all I will say about that part. The part about Section B, sir, requires a little explanation. Sir, when you import, or a dealer imports a firearm, like I guess most cars, it comes with certain basic maintenance parts. You get by a car, you get a jack and a spare tire, or you get run flats and a juice to put in it. Well, depending on the grade of car you buy, you may get a jack and spare tire still. When you buy certain firearms, sir, you get certain spare parts. And it therefore stops the possibility of criminalizing licensed firearm holders for holding those spare parts. It doesn't give them permission to go out and buy spare parts and bring them in, but the ones that you possess, it allows you to keep. Sir, I wish to make a comment about the importance of an inclusion in this amendment in clause 2B. I think the government wisely has chosen to put the term automatic sphere in it, because this matter is a matter that has caused tremendous problems in the north. And this government, I believe, will be taking steps to make sure that the problems being experienced in the north, where persons are converting semi-automatic weapons to full automatic weapons, does not happen here. But it does not remove the problem, sir, of 3D printing. And there is evidence that with the advent of technology, useful technology, that some technologies are subject to abuse. I understand that one requires a license to have a 3D printer, but there is no regulation, sir, of what you can print. So there still needs to be some serious scrutiny of what people are printing on their 3D printers and what they're being used for. This legislation and these amendments, sir, will not fix all the problems. Sir, there is a problem that has happened probably inadvertently because of this amendment. And I wish to spend a little time explaining it. The sport shooters, the Olympic shooters, who for years have complied with a police requirement of having reduction in the number of guns you're required to have to shoot Olympic disciplines, have become accustomed to using what is called a conversion, where you buy one frame and you fit different calibers on top of that frame. It means that at any one point in time, you only have one firearm. Over the last 10 years, these firearms have become a point of controversy for shooters, and they have not been licensed. Because there's the contention by the constabulary at its highest office that there are two firearms. It means that shooters have had in their possession firearms that have not been licensed. So when a shooter takes one of those firearms to a shooting club, and if there is an accident, the liability insurance of the club will not cover them. But that's a problem created by the government for failure to license the firearms. This amendment, sir, unfortunately, now makes those firearms illegal. So those who own them, I believe, will have to turn them in. I would like to believe that the government will offer them compensation, because I would like to believe the government, sir, will offer them compensation for their loss. Because as happened in other jurisdictions, when something that you were given permission to have becomes illegal, then, and you're required to turn it in, you will usually be compensated for your loss. Sir, with those few words, I thank you.
Thank you very much, Senator Miller. Any other speakers? Senator Cummings.
Thank you very much, Mr. President. I was trying to avoid mentioning Senator Maynard directly, but I do want to thank him, having spoken, for his comments and his detailed comments and his acknowledgement, no matter how painfully he did it, that this is a listening government. And so with these few words, almost, Mr. President, and so with these few words, I beg to move that this bill be read a second time.
The question is that this bill be read a second time. Will those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that the Senate resolve itself into committee for further consideration of this bill.
The question is that I do not leave the chair and the Honorable the Senate resolve itself in the committee for further consideration of this bill. Will those honorable senators in favor please say aye? Those against please say no. Methinks the ayes have it.
The Honorable the Senate is now in committee.
Clause 1.
Mr. Chair, I beg to move that clause 1 stand part.
The question is, clause 1 stand part. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Clause 2.
Mr. President, I beg to amend clause 2 at section B as follows to read, in the definition of firearm, we're deleting the existing paragraph B, and the new paragraph B would read, includes any major component part of a weapon referred to in paragraph A, 1, 3, 4, 5, specifically designed for use in a firearm, including a barrel, slide, frame, hammer, firing pin, auto or automatic sear, trigger, bolt, and magazine, but.
The question is that clause 2 be amended as follows, includes any made in the definition of firearm, delete paragraph B and substitute the following. B, includes any major component part of a weapon referred to in paragraphs A1, 3, 4, and 5, specifically designed for use in a firearm, including barrel, slide, frame, hammer, firing pin, automatic sear, trigger, bolt, and magazine. But the question is that clause 2 stand part as amended. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. Chairman, we are having an amendment by the insertion of a new clause, which will now be clause 3.
Mr. President, I beg to move that we have an amendment that reads as follows in the new clause 3. A firearm license shall obtain permission for the holder to have in his possession A, ammunition of a type and not exceeding an amount specified in the license, and B, such parts or accessories as are reasonably necessary for the repair, maintenance, or use of the firearm to which the license applies. I beg to move that this amendment, this clause 3 do now stand part as amended.
Mr. Chairman, and just for clarity, the new clause will have as its heading, amendment of section 5 of Cap 179. It says section 5.4 of the Principal Act is deleted and the following substituted. That's all part of the new clause.
Sorry, section.
This is the heading. This is what is there, and this is the new language.
The question is that clause 3 be amended as follows. Section 5.4 of the Principal Act is deleted and the following is substituted. A firearm license shall contain permission for the holder to have in his possession A, ammunition of a type and not exceeding an amount specified in the license, and such parts or accessories as are reasonably necessary for the repair, maintenance, or use of the firearm to which the license applies. The question is that the clause as amended to stand part. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Sir, as a result of that insertion, clause 3 now becomes clause 4.
Mr. President, I beg to move that the current clause 3 now becomes renumbered as clause 4. I beg to move that the new clause 4 do now stand part.
The question is that the current clause 3 be now renumbered as clause 4. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Mr. Chair, I beg to move that you do not report to His Honor the President the passing of one bill in committee.
The question is that I do now report to His Honor the President the passing of one bill in committee. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
The chairman has reported the passing of one bill in committee.
Mr. President, I beg to move that this bill be read a third time.
The question is that this bill be read a third time. Will those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do not pass and be cited as the Firearms Amendment Act 2025 as amended.
The question is that this bill do not pass and be cited as the Firearms Amendment Act 2025. Will those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 15, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Jury's Bill 2025.
Senator Cummings.
Thank you very much, Mr. President. The Jury's Bill is an antiquated piece of legislation that the Office of the Attorney General and the legal practitioners are attempting to update to make it more functional. There are a number of changes that I will refer to perhaps briefly. In this instance, we have, Mr. President, through the sections of the legislation, Part 1, standard short title and interpretation. Part 2, you will see that there are some changes made to the qualifications, disqualifications, exemptions, and so on for jury service. The compilation of the jurors list at Part 3, that has been a piece of antiquated legislation. The summoning of jurors in clauses 12 through 16 is going to come up, and I will speak in a few moments about the question at clause 16, the remuneration of jurors, which still exists at $10 per day in 2025. The selection of juries is covered in Part 5 of the legislation through clauses 17 through 23. Then we move on to the procedure for navigating juries at Part 6, separation through the discharge of the jury before the verdict. What happens in verdicts is in Part 7, clauses 29 through 36, and then there are a number of miscellaneous provisions. Now, Mr. President, I remember as a history student coming up in a time where we were chattel, and we had to be treated as such. There was a time, Mr. President, where a parliament sitting in a session just like ours, determined that it was no longer appropriate for people to own property in order to vote. Yet, in our jurors legislation, there is still a provision that requires a juror to be selected to have the possession of property with a site value of at least $960, so you can tell how old this was, to be an occupier of land that values under the Land Valuation Act of no less than $1,400, to have property taxes of no less than $960, and to have clear income of no less than $1,400. Clearly, that is no longer applicable in a modern environment. On the question of exemptions, those persons who were exempted, we saw that at part 2 from jury service. There were a number of persons that were exempt from jury service. Members of the Privy Council, members and officers of the Senate and the House of Assembly, judges, magistrates, ministers specifically, not of any other religion, but of the Christian religion, ordained or otherwise set apart to the ministry of that religion according to the usages of the persuasion to which they belong. Heads of missions within the meaning of diplomatic privileges and immunities, consular officers or consular employees, members of the armed forces of the Crown, well, now the state, members of the police force, now the police service, persons employed in the public service as part of the Judicial Advisory Council may provide regulations, commissions of probate, officers of the court of law, legally qualified medical practitioners, and spouses of all the above. Equally, in a modern environment, Mr. President, there clearly is a need for us to make some changes. As I go on, Mr. President, in the existing section of the Act which talks about a judge, it says this, in the existing section 26, a judge before whom a case is called for trial may, in his discretion, could you imagine in 2025, on an application made by or on behalf of the parties, including in criminal cases, or any of them at his own instance, make an order that a jury shall be composed of men only or of women only. That, Mr. President, has been deleted from the legislation. There's a section in the legislation, Mr. President, also that speaks about how jurors are compiled and the jurors list. These are antiquated provisions, Mr. President, that said the following under the existing section 11. It says this: the preliminary list of jurors is to be exhibited in a conspicuous place open to the public at the magistrate's court for that district and all police stations in that district. The purpose of publicizing the list in this way was supposedly to facilitate the objection to persons being on the list and applications to the magistrate for removal from the list. This has not been used in a long time, but yet it continues in the legislation. Equally, there is now a provision for alternate jurors where there was none before. There was an antiquated term called embracery, which was there. It is really the offense of influencing or attempting to influence a juror by corrupt acts, threats, or promises. And so there's now a new offense listed at Clause 4, which brings it into a modern environment. So these are some of the changes that have been made to continue with the updating of our suite of legislation to allow for us to bring it into the third decade of the 21st century. And so, Mr. President, I commend this bill as well as part of the suite that we are considering today, and I beg to move that this bill be read a second time.
Speakers, the question is that this bill be read a second time. Send us the date.
Sorry, Mr. President.
That's fine.
Half asleep. Oh my goodness. Mr. President, my apologies. And I blame Senator Boyce too, that helps. Looking at this jury's act, right? This jury's bill. I was looking at, sir, the transitional section 43, which says, notwithstanding section 45, all trials started before the commencement of this act shall continue in accordance with the provisions of the Juries Act, Cap 11B5. Oh, wait, sorry, 115B. I'm there. And then clause 45 says that the Juries Act, Cap 115B is repealed. So I'm just wondering, I understand the concept and why it is that it has to be so, but I'm just wondering if the wording of clause 43 couldn't be slightly different, because it's either that you change around the sequence or you change the wording, because you're making reference and you're saying all trials before have to continue under the act that is to be repealed. And I get the concept, I'm just wondering about the wording. I'm just wondering. Thank you, sir.
Thank you, Senator Day.
Thank you very much for your comment, Senator Tate. It will be appropriately conveyed to the Office of the Attorney General. I beg to move, Mr. President, that this bill be read a second time, having not responded to the query.
The question is that this bill be read a second time. Will those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Mr. President, I beg to move that you do not leave the chair and the Senate resolve itself into committee for further consideration of this bill.
The question is that I do not leave the chair, and the Honorable the Senate resolve itself in the committee for further consideration of this bill. Will those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
The Honorable Senate is now in committee.
Mr. Chairman, permission to call in clauses and parts.
Granted.
Part 1, clauses 1 and 2.
Mr. Chair, I beg to move that Part 1, clauses 1 and 2 do not stand part.
The question is that Part 1, clauses 1 and 2 do stand part. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Part 2, clauses 3 through 6.
Mr. Chairman, I beg to move that Part 2, clauses 3 through 6 do not stand part.
The question is Part 2, clauses 3 to 6 do now stand part. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Part 3, clauses 7 through 11.
Mr. Chair, I beg to move that Part 3, clauses 7 through 11 do now stand part.
The question is that Part 3, clauses 7 through 11 do now stand part. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Part 4, clauses 12 through 16.
Part 4.
Mr. Chair, I beg to move that Part 4, clauses 12 through 16 do now stand part.
The question is that Part 4, clauses 12 through 16 do now stand part. Will all those honorable senators in favor please say aye? Aye. Those against please say no. Methinks the ayes have it.
Part 5, clauses 17 through 23.
Mr. Chairman, I beg to move that Part 5, clauses 17 through 23 do now stand part.
The question is that Part 5, clauses 17 through 23 do now stand part. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Part 6, clauses 24 through 28.
Mr. Chair, I beg to move that Part 6, clauses 24 through 28 do now stand part.
The question is that Part 4, clauses 24 through 28 do stand part. Will all those...
Chairman, Part 6.
Part 6, beg your pardon. The question is that Part 6, Clauses 24 through 28 do now stand part. Will all those honorable senators in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Part 7, clauses 29 through 36.
Mr. Chair, I beg to move that Part 7, clauses 29 through 36 do now stand part.
The question is that Part 7, clauses 29 through 36 do stand part. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Part 8, clauses 37 through 45.
Mr. Chair, I beg to move that Part 8, clauses 37 through 45 do now stand part.
The question is that Part 8, clauses 37 to 45 do stand part. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Schedule.
Mr. Chair, I beg to move that the schedule be the schedule to the bill.
The question is that the schedule be the schedule to the bill. Will all those honorable senators in favor please say aye? Those against, please say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honor the President the passage of one bill in committee.
The question is that I now report to His Honor the President the passing of one bill in committee. Will all those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it. That's the last one.
The chairman has reported the pass of one bill in committee.
Mr. President, I beg to move that this bill now be read a third time.
The question is that this bill be read a third time. Will those honorable senators in favor please say aye? Aye. Those against, please say no. Thinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Juries Act 2025.
The question is that this bill do not pass and be cited as the Juries Act 2025. Will those honorable senators in favor please say aye? Aye. Those against, please say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 13, sir. In the name of the Honorable Leader of the Senate, to move the second reading of the Police Amendment Bill 2025.
Senator Cummins.
Thank you very much, Mr. President. This is not, unlike the other pieces of legislation, a small bill. This has several sections, and I want to go through them for clarity for the honorable members in this chamber and for the members of the public. This is a piece of legislation that, like other pieces of legislation, have existed in the corridors of antiquity and have needed to be brought into a contemporary space where, like much of our other legislation, they needed to be updated to deal with the moment in time that we're living in. In the first instance, Mr. President, there is a specific reference to how we treat to persons who have served as special constables. Many of these persons who have served as special constables have been policing the country alongside regular policemen. They have been working in multiple spheres, Mr. President. However, despite the exposure, like everyone else working in law enforcement, they did not have the benefit over an extended period of time from the same benefits as regular police officers. They were, in law, treated as casual workers instead of public officers. They received pensions in accordance with the Casual Employees Pension Act, and they had any number of appeals being made to governments over many years to be able to have this regularized. This act before us is now here to be updated and amended as proposed to ensure that in keeping with a 2020 policy directive that we now regularize the service of special constables in this country. The legislation which was dated needed to be brought into alignment with that 2020 policy position, and on that basis, the proposal is to amend the Police Act, Cap 167, in order to afford special constables the status of public officer so that they will be able to receive the same benefits that I mentioned before under the Pensions Act, Cap 25, rather than as they were historically for all this time under the Casual Employees Pensions Act. Mr. President, in 2025, earlier this year, in the budgetary statement, in the other place, it was announced that with effect from this financial year 2025-2026, that special constables who have served in that capacity for more than 3 years will automatically be transitioned into the Barbados Police Service if they opt to do so. Now, there's no question, and I think we've mentioned it on more than one occasion, that the police service has had a shortage in numbers, and they have seen fewer persons opting to go into the disciplined services. And so the opportunity for persons who have served as special constables all of this time are then being allowed for them to make that transition if they so desire. So the proposal, therefore, requires an amendment. That amendment is before this honorable chamber. And there is no provision currently in the legislation by virtue of being a special constable that allows you to transition, even though you've been functioning in the space. And so it is before this honorable chamber to approve the amendment that will allow for this transition to take place. Now, in addition to members of the special constabulary who have been working alongside the Barbados Police Service, there is another category of professional that has also been doing the same thing. We see all the time the members of the Barbados Defense Force. Members of the Defense Force have historically always been deployed to give operational support to the police service for the purpose of securing and maintaining public safety. However, they have not had any of the privileges or the immunities of the police officers alongside whom they work. And so it has been the view of the National Security Council of this country that when the Defense Force personnel are deployed, that they should have the same provisions made available to them as police officers, and that includes the power of arrest. They should also have identical privileges and immunities afforded to them as seen with police officers. An amendment is before this honorable chamber, equally so, Mr. President, for this to be effected. Now, Mr. President, I am 100% certain. Last week, on Sunday, my church, no, I think it's finishing this Sunday, is running a Summer Steps Challenge. I can't ever win the Steps Challenge, ever to get in the most steps. But movement, wellness, fitness is a conversation that the country is having, and it is applicable and has been applicable in the Barbados Police Service. Physical fitness, your ability to chase down a suspect has always been seen as a criteria for entry into the Barbados Police Service. But, Mr. President, and I did say already on more than one occasion, I will say again in this context, the criminal of today is not the criminal of 10 years ago or the criminal of 20 years ago. It is a different criminal. So the notion that the only role to be played by a police officer is chasing down a criminal who is a purse snatcher or any of those things is a nonsense. We've talked about all kinds of things, including use of technology, how innovative criminals are getting, how they're using transnational organized groups to be able to conduct themselves in ways that will cause damage to their communities. The criminal today is not the criminal of yesterday even. And so the notion that physical fitness is the only criteria is being dismissed in this amendment. So for example, and there's an example being drawn from Jamaica, the Jamaica Constabulary Force is now seeking to recruit a police officer who has mobility challenges. He certainly can't run down behind nobody. The purpose of recruiting this individual, however, is that he has superb forensic digital skills. And so in the same way that in every other sector of the society, skills are evolving, the same thing applies to the police service. And so on that basis, this amendment to this legislation also is allowing for, where applicable, the Commissioner of Police should have the ability to waive or alter the physical fitness requirements that allow for the recruitment of police officers to allow for the range of skills and competencies required for the act of policing. Equally so, there is an opportunity that is now being taken to tidy up the existing legislation, specifically in the existing Section 32 of the Act, 32A, where there is a disciplinary code which is included in the Act, and we have seen and heard in this honorable chamber on more than one occasion that there are certain types of things which are specifics that do not belong in the legislation, but rightfully belong in schedules to the legislation. And so in this instance, the disciplinary code is being repositioned to being in a schedule. So, Mr. President, there are also a number of new provisions. One of those new provisions is to allow for the Commissioner of Police to enlist a person into the service who possesses such special skills as required by that service to deal with the modern-day criminal and the ones still to come, to enhance its operations, but who do not meet the stipulated qualifications as they exist. Obviously, Mr. President, we're not removing the requirement for things like basic good character. Those things remain and will remain in force, obviously. There were changes made to the legislation over the last little while in the Constitution Amendment Act, where the police force was hereinafter at that time referred to as the Barbados Police Service. And so the opportunity is being taken to make the change throughout all instances where that legislation presents itself, and then to have the Barbados Police Service, as we now call it, the BPS, reflected throughout the legislation. This, Mr. President, captures the various sections that I have just gone through in detail from clause 1 through clause 32. It also includes, Mr. President, clause 31, where there are consequential amendments required, and also the revocation requirements for the existing legislation. And so, Mr. President, with these few words, I beg to move that this bill be read a second time.
Senator Walters.
Thank you, Mr. President. As I review the bill that is before us, Mr. President, a couple of things popped out, and actually brought back some memories of the Prime Minister when last September she made the comment that she doesn't want money. Sorry, she doesn't want to prosecute them, she wants money. The fines in this bill, Mr. President, moved from $500 to $10,000 in some instances, from $1,000 to $10,000 in others. Where there were no fines, the fines were introduced at $50,000. Some fines moved from $2,000 to $20,000. Some from $300 to $10,000, Mr. President. And quite a few moved from $1,000 to $20,000. And the rationale from the government is that they wanted to modernize the bill, or modernize the act. It must be noted, Mr. President, that the words that accompanied the clauses of those sections did not change. Only the amounts of the fines changed. What is of great concern, though, Mr. President, is that Section 68 has caused some alarm in the public domain, because although some of these stipulations have already been in place for many years, the public is not really aware of a lot of the legalities or a lot of the laws that fall under this act. And Section 68 refusing to aid a member of service assaulted. If I may read, Mr. President, it says, any person who, when called upon to aid and assist a member of the service, who, while in the execution of his duty, is assaulted or resisted or in danger of being assaulted or resisted, refuses or neglects to aid and assist a member of the service, is guilty of an offense and is liable of a summary conviction to a fine of $10,000 or to imprisonment for 1 year or to both. Previously, Mr. President, that fine was $500 and the imprisonment term was 6 months. It is a cause of concern because it is quite unclear. The layman, the average person reading that would assume that they need to get involved in business that they have no, in the activity that they have no business in. And it is very unclear as to the circumstances around where they would be charged with an offense if they are in the neighborhood of a situation where a policeman might be under duress or in problems, and they are even themselves unable to assist. So I think, while this existed, it needs some clarity. It needs maybe to be removed from the act, or it needs to be put in another form that makes it fair to citizens who are just going about their normal business, who might find themselves in the wrong place at the wrong time. Mr. President, Section 79A is the insertion of a new section 79A, Mr. President, and it says that it's assistance from the Barbados Defense Force, and it pretty much gives those persons of the Defense Force, Mr. President, the powers, authorities, privileges, responsibilities, and immunities of a member of the police service. And the question here, Mr. President, is the level of training that the persons in the Defense Force would have relative to the training of those in the police service in terms of their service, in terms of how they handle and treat the situations. And you know, in the past, Mr. President, you would see a police officer with a baton, and the baton was used in specific instances. Very often now you see police with a firearm. Obviously the times have changed, and they might have a firearm and a baton, but obviously they're trained in how to use each tool that they're provided with in each situation. So the question that we're asking on behalf of the public is what sort of training that the Defense Force will go under to deal with situations when they come in to deal with civilians, Mr. President, because all circumstances will not require the use of a firearm or the use of a firearm in a space where there might not be need for, there might just be need for restraint and control, but not the use of actually having a firearm in apprehension or in controlling a situation, Mr. President. Similarly, Mr. President, the whole notion of transitioning the constables into service, the special constables into service, I think that is very reasonable. I think that it is hard to ask someone to do a similar job of another person, especially for a long period of time, and they're not compensated in a similar manner. So I don't think there's any question there, but generally, there are basic concerns that we have seen in the press over the last few months, and that is pretty much one of pay, where you often see the police association asking for payment of overtime or negotiating some terms of payment for services that they have done above and beyond their regular duties. And I don't think, Mr. President, that anyone on the government side is giving free labor and I don't think that the police service and the members of the police service should be offering free labor. Just as recent to last week, there was a report where they have not been paid for the 6-day-a-week commitment from June to August 11th, I think it was, Mr. President. And I think if we are going to treat to the police service, if we're going to make amendments to the act and the legislation, these are some of the salient things that we need to do that may sit outside of the legislation, but are really needed in terms of working with the force and building up that resilience in the force, Mr. President. And you would wonder why the force is unable to recruit persons. Well, a young man or a young lady picking up the newspaper and saying every 6 weeks, the police association begging for equal pay, for overtime that they've worked, etc. Who will be interested in going into service under those conditions? Mr. President, I have been made aware that it is not only the normal overtime that we would think if they're out to shift work and something happens on duty and they have to work over 8 hours, but it includes things like going to court on off days, and national duty in natural disasters. And I am told that up to now, the police officers have not been paid for the overtime in the hurricane last year, Mr. President. These things are not fair. I think, Mr. President, that the time has to come that the government, or any government, needs to put the resources where they are needed. And if we are talking about crime and combating crime, it is fine to put legislation in place, but the persons that are charged with addressing crime day in, day out, 24 hours, that they need to be dealt with in a respectable and fair manner, Mr. President. So the government, Mr. President, has found the resources to do a lot of things in this country, including paying consultants a lot of money. And we have heard the stories of the $120,000 a month for consultants that are helping on different initiatives in the government. We've heard the amount of money that have been paid in the restructuring of the debt. Millions of dollars have been spent, Mr. President. And I am saying that it is only fair that the police officers get their just due, and they deserve to be paid what they earned. Mr. President, some on the other side may seek to reduce this as a 2013, as a BLP government did this and the DLP government did that. I am saying to you, fair is fair. Labor should be treated in a fair manner. And in this instance, we're talking about the police officers. If they work overtime, Mr. President, there's no reason why they should not get the overtime. There's no reason why, if they're committed to national service, work 6 days a week over the last 3 months, that they should be in the paper complaining that they have not been paid, Mr. President. There's no way, Mr. President, that if they were on national duty during a hurricane last year or in the aftermath of a hurricane, committed to the people of the country, that they should not be paid almost 14 months after, Mr. President. Mr. President, Mr. President, Mr. President, the leaders of the government side are talking about Hurricane Elsa. Could we remind the government, Mr. President, that Hurricane Elsa, there was some destruction to homes, and the government sought, Mr. President, to import homes into this country from China, steel frame homes, $27 million in overruns, Mr. President, money that could be used in the police service, Mr. President. This is no comparison. No comparison. And it could go on with the wastage of this government, Mr. President. Mr. President, it is the priorities of the government that send a signal to the people of this country. As I said previously, it is okay, Mr. President, to come and you put legislation in place. but there are people working on behalf of the citizens of this country, working for government, and they need to be taken care of. Accommodation of police officers. Police stations are in a state of disrepair, Mr. President. They need significant rebuilding and significant maintenance programs. This is where we need to spend our money, Mr. President. So we can talk about amendments to the legislation where we're moving the special constables into police officers. But if they're not getting paid, what sense does it make, Mr. President? If they still have to go into a dilapidated building that is sick, what sense does it make, Mr. President? When the government has at its disposal and has borrowed over the last few years close to $2 billion, Mr. President, that taxpayers are repaying in interest payments, Mr. President. These are critical things that our policemen and women should be working in better conditions. When we speak about police men and women, Mr. President, we have to look also at the tools and equipment that they have to work with. Mr. President, these things may seem simple, but I am told, Mr. President, that something as simple as replacing the vehicles that the police officers use is an issue, because their vehicles are not like yours and mine, that when we go home after 10 hours, we drive to from work, maybe to the supermarket at Saturday Park. They are moving from shift to shift, 24 hours a day. And I understand that in the past, there was an agreement to change these vehicles every 3 years, Mr. President. And now, we have a situation where this is not being done, and where these vehicles have challenges, issues that could not only pose a danger to the officers themselves, but to the general public, Mr. President. These are things that need to be addressed. The quantity of equipment that the police officers have. I am told, Mr. President, sorry, I am told from the police force that something as simple as handcuffs are not in adequate enough number, and that police officers purchase handcuffs themselves in instances so that they have the tools to work with. Mr. President, the government may want to make light of these comments, but it shows that they are not interested in the duties and the people that are charged with carrying out these duties if they make light of these concerns, Mr. President. So, Mr. President, without keeping the chamber too long, the amendments, well, they may seem reasonable in terms of bringing in line with, as they say, modernizing. We think some of the penalties have gone too far in terms of they have moved astronomical in size, and we think, Mr. President, that the issues in the police service is what the government must also pay attention to, and not only with amending legislation and putting things on paper in writing, but to treat to the men and women who are out there every day working on behalf of the citizens of this country to maintain law and order. And with those few words, I'm obliged.
Thank you very much, Senator Walters. If no other speakers, Senator Tate.
Mr. President, may I sit, please?
Certainly.
Thank you. Mr. President, I as usual.
Senator Morris, please.
I wasn't sure it was far away. Mr. President, as usual, I will be asking questions or seeking clarity. Oh, sorry. But I don't start at 11, I go till 11, so my back hurting. Y'all stay there. Mr. President, I see that with this bill, we are finally regularizing the name of the service to make it line up with the Constitution. I'm just wondering, and this is really, I'm just curious why it would have taken 4 years. It doesn't need to be answered, I just find it took a little while. In terms of the proposed bill, Mr. President, Clause 6 of the bill speaks to the composition of the service, and it makes reference to a commissioner and such number of deputy commissioners with an S, which is a result of back in the day, as we all know. I just want to highlight, because it's what I do, that Section 9 of the Principal Act still makes reference to a single deputy. So if you create your Clause 6 and you delete your Section 6 and so on, you need to fix your Section 9, but I haven't noticed that the bill has made an amendment to Section 9. Did that make sense, sir? So Section 9 of the current bill makes reference to a single deputy commissioner. But if you're going to have such number of deputy commissioners by virtue of the amendment, you would need to address Section 9 of the current bill, which was not addressed in the, you would need to address Section 9 of the Act, which was not addressed in the proposed bill, to line it up with having more than one deputy. Okay, so I'm sorry, everybody's tired, I'll say that again. You get it? You get it? You get it? The president is looking at me like I talking gibberish, and I don't like when he looks at me like that. I would go further, sir, to suggest...
I get it, I'm just not the one to give the answer.
Oh, I would go further, sir, and say that if it is that you're going to make provision for more than one deputy in Section 9 of the current Police Act, you may wish to make reference to a deputy commissioner in order of seniority. That's just my humble suggestion. With respect to the proposed Clause 9, if you pay me right, if with the proposed Clause 15, it says that Section 29 is to be repealed and is to be substituted, and it's going to be dealing with the subordinate police officer or constable who absents himself from duty or resigning. That bill currently exists, but my question really is, I usually ask this question, when legislation is introduced and it's going to directly impact people, are they notified? That was my issue with the integrity bill, and this is something that will also concern me, because in the Act, Section 29 speaks to a $1,000 fine if someone illegally resigns from or leaves the service. But now that person will be faced with a fine of $10,000. So I'm wondering if that has been shared with the police, and I think it came to mind simply because I believe Senator Walters made reference, and everybody saw that leading up to crop over, the police were not happy, and there was talk about us having a challenge with police during crop over. A policeman, and you're hearing a lot about police leaving the force is under manned, people are going to other jurisdictions, et cetera, because things are not the best here. And I'm wondering if you're going to impose this, if you have shared it with the goodly men and women of the Barbados Police Service. I believe in the lower house, the bills were dealt with in a cognate debate. And I believe that there is a moral and there's a responsibility that when that happens, you should at least highlight the changes that you have made as you deal with the bills. I certainly didn't hear anything like this, and somebody would think that this is not important, but people are leaving. And you can't be leaving a space where you're not being paid and then be faced with the possibility of having to give up $10,000 because you did not follow what was supposed to happen because you didn't know it had been amended. If you don't have anything to hide, share the amendments because, again, as Senator Walters noted, and I also noted that there was a lot of talk about modernization of the legislation, but there are a number of sections that will be amended, and the only words that are amended are the fines. So when you look at a section like Section 45, I believe it is, of the Act, and here's the thing, I'm gonna fast forward, Mr. President. Go to page 17, sir, if you're following, and you will see that there's a repeal of Section 44. There's a repeal and replacement of Section 46. That is in the form of clauses 20 and 21. There's a repeal of Sections 47 and 48. But you see Section 45, Mr. President? That hasn't been touched. We are doing modernization, but if you would bear with me as I find Section 45 so I can read it to you, sir, I'm just wondering, you know, what's the ultimate agenda, because I don't want to get the sense that it's just modernization for the sake of increasing the fines, because is that what we're doing? So Section 45, subsection 3, in its current form, sir, says, and I'm just reading it, the police association shall be entirely independent of and unassociated with any body outside the force other than a police association within the West Indies, Guyana, or British Honduras. British Honduras is what, Belize? I'm just making the point, this section was not amended according to clause 20 and 21 and 22. Section 44 is being amended, 46 is being amended, 47 and 48 and 49, but not 45. But we're modernizing the legislation, but we still have British Honduras that is going to be taken along with the amendments into the new legislation. So perhaps for free, the government might want to look at that in terms of their drafting. It may be pernickety, but I mean, if you're modernizing, you really shouldn't be carrying forward British Honduras in your amendment. No, this is dealing with the police association, Mr. President. So that's probably why it did not get into the purview of the persons who are doing the amendments. I'd like to, I'm sure it was, I'd like to continue, and you know, that's why it was, that's what made me look at it, because everything around that section was either repealed, deleted, or amended, but not Section 45. So I wanted to see, well, what's in 45 that nothing happened to it, and it's gonna go into the, it's going to remain in the Act, but yet we have a reference to British Honduras. I find we can do things well if we spend time doing them well or doing them properly. I continue with clause 16, sir. So you have to turn, if you're interested in doing so, sir, back to page 13. So Section 31 is repealed and it's going to replace. In Section 31, I mean, who knew that these things exist? But this basically deals with somebody who assists a member of the service to illegally resign. So the fine has increased from $1,000 to $10,000. There seems to be a focus on the you're trying to prevent the police from resigning or leaving, but yet they're not happy. But you got them tint though, but you didn't get them the $800 that they were looking for, but they still have tint. So we go from the person assisting with resigning goes from $1,000 to $10,000. But you know what I've been noticing about those sections that carry up the amount? The rest of the legislation, the words remain more or less exactly the same. So the modernization clearly is related to cost or increase in penalty. That's kind of, it was an interesting observation for me. Section 32 was repealed and it's being substituted I'm at clause 17, sir. I beg your pardon, page 14. So you have, in the original, there would have been 3 years in prison. Oh, there was no money and 3 years in prison if you were engaged in mutiny. Now you have to pay $50,000 and 3 years or both. If you engage if you help somebody with mutiny, it goes from $2,000 and 12 months in prison to $20,000 and 2 years in prison. I'm just wondering where the modernization is in all of this, because I know, I'm just making sure I'm listening, Senator Walker. And then we go to clause 18, and this was the one that was the most eye-opening for me. The clause 18 gives the Commissioner of Police the power to impose a fine of $10,000, stop and leave at the Commissioner's discretion, reprimand or severe remand, etc., etc. But that used to be $300. So I suppose that would be a modernization move. But I'm understanding, though, that the superintendent of prisons, his power stops at $25. So I'm just marveling at the modernization that's taking place with the Police Act. And then we're doing modernization, and we're still seeing reference to punishment drill. And I would have thought that if you're modernizing, would have been removed, because my understanding of punishment drill is archaic. That's how we used to treat conscripts. I'm not sure that we should still be doing that with our people. And it can exceed 14 days, but punishment drill is, my understanding, quite draconian. I'm just asking, sir, what the focus is. And, you know, I always maintain that if you're going to have this type of thing going on, you really ought to tell the people to whom it's going to, who will be affected by it. Another thing that is of great concern to me, well, I shouldn't say great, because I don't go anywhere and behave badly. Clause 19, sir, that would be on page 16. It says that Section 38 of the Principal Act is deleted. And we have offenses in ports and harbors. So the new section, if passed, will make reference to any person who in Carlisle Bay or in any port or harbor of Barbados, A, boards, holds, or clings on any vessel without the permission of the master, B, makes use of any obscene, indecent, profane, or insulting language, or C, makes or causes to be made any disturbance, is guilty of an offense and liable on summary conviction to a fine of $10,000 or imprisonment for 1 year or both. That's the proposal. It used to be $500 and 6 months. It's gone to $10,000 in a year, but the second part is the one that concerns me, because that whole port thing, people go on those cruises and they get drunk and they get obscene, which would be the initial makes use of any obscene, indecent, profane, or insulting language. But here we have a member of the service may, without a warrant, arrest any person who in his presence commits an offense under this section. I think perhaps this should be advertised. I feel people should know about these things. It might stop them from doing things that an officer shouldn't have to deal with. I'm just wondering if that is something that would be even on the police IG page or something like that. The final thing I have a concern about, sir, or I'm querying, because concern is such a strong word. It says that part 1011 of the Principal Act is deleted and the following substituted. Well, apart from the fact that a lot of the new part 11 repeats the old part 11, so I'm not sure why we had to delete the whole thing to put it back, but the drafting that happens on behalf of the government is not within my purview, so I'll just leave it at, you gotta find work for the consultants to do, I guess. But you know what concerns me? The proposed section 62(1)(c). Any person, oh, no, let's do 62(1) in its entirety. Any person who A, assaults, obstructs, or resists, or B, uses any abusive or insulting language to, or C, aids or incites any person to assault, obstruct, or resist a member of the service in the execution of his duty, or any person acting in aid of any such member of the service, is guilty of an offense and liable on summary conviction to a fine of $20,000 or to imprisonment for 2 years or to both. But if the magistrate is of the opinion that the matter is fit for prosecution by indictment, he shall commit the offender to stand trial at the High Court. I have two concerns about this. This is a concern. If you engage in mutiny, it's a $50,000 fine, but if you assault one of our police officers, it's only $20,000? I'm confused. I find that it should be higher. Why are we assaulting police officers in the course of the legitimate course of their business? Why are we not protecting them more? $20,000 versus $50,000 if you engage in mutiny. The chances of engaging in mutiny are so much lower than somebody affecting or interfering with a police officer or a policewoman. I would think that that needs to be looked at. The other thing that I'm concerned about is that the magistrate can send it for indictment, but it doesn't go on to say what the fine penalty would be. It's not addressed. So I would think that that needs to be addressed, because if you're gonna have a fine of $20,000 or imprisonment for 2 years or both at the magistrate level, the magistrate thinks it's fit for prosecution by indictment, but there's no indication up to what level such a charge would attract. That should be addressed because it's missing. Again, that is my observation as it relates to the proposed clause 24. The other area of interest was the clause that broke the internet with the $10,000 if you fail to assist an officer. A lot has been said, and I suppose rightfully so, but here's my concern. In an environment that exists with crime in Barbados, where we had an elderly lady out by the NIS bus stop, where she was robbed of her bracelet, of her jewelry. And that's one of the busiest areas around that time of the day. There's always traffic on Culloden Road. She didn't get any help, really. It was filmed, though. We are good, we film. So she didn't get help. And then the gentleman at Belmont Road by the credit union, I mean, you can even watch that video, Mr. President. It was so horrific. Cars were passing, it was filmed. I'm not judging anybody for not helping, because you can't help these days, because you don't know. Back in the day when there was fetting that I attended, you didn't want to mash anybody's foot because they might chop you. Go forward a few years, because it's only the other day that, that age, that. So I'm saying, if we know already that our people are, I would say, afraid to help, how are we going to deal with this clause, this proposed clause that can get us charged $10,000 when we have people who needed help, who were elderly? Back in the day, Barbadians, nobody would have been so stupid to interfere with anybody, particularly in those busy areas, particularly with elderly persons. That's not who we are. So we are afraid. People respond with knives and guns now. And the guns, according to the talk, are more modern, faster than that which are issued to our police service people. So how are we addressing this, and how was this allowed to be imported into this proposed amendment from 1975 when it first went into the legislation? In 1975, the most that would happen is you would get hit with a rock stone, or you might get hit by the back of a cutlass. That's not happening today. So I would be interested to hear how the government proposes to make that clause work in light of the fact that we have two separate but real examples of people who needed help but didn't get it because, I guess, of the fear. And I have always asked, are the police protected by insurance or whatever, or any, not whatever, are the police insured with employer's liability with some kind of coverage if they get injured on the job, or is it a government payment? And what is the position if you tell me I have to help and I help and I get injured, or worse yet, I get killed, or I have a permanent disability? What is, and a permanent disability costs more than if you die. Okay, so what is the plan is my question, because you left it in. And this government changes, repeals, and removes for sure. So we had, NIS is now something else, national something, it now has 6 letters, and we changed town planning department. We changed, for sure, we changed government house to state house. So that suit you. So we took that. We didn't, and we knowingly took it because we changed the fine. What's the plan? How are you going to enforce it? How are you going to protect the civilian who is not trained to help? Why did you bring it over when it was of 2 different eras? That's like 40, how much years ago that was? 50 years? What are we doing? I'm just asking, Mr. President. So, as it relates to this bill, I just have these questions that I would love to have answered. Just, because I think they should be answered. I think that the people of Barbados, and more importantly, our good men and women of the Barbados Police Service, have a right to have these areas clarified. They need to be educated. They need to be informed. And with that, sir, I'm obliged to you.
Thank you very much, Senator Tate. Senator Robert Morris, and then Senator Boyce.
Thank you, Mr. President. I sat here and I listened to a presentation from the opposition senators regarding, one, the police force. And, sir, in this chamber, I thought that we would rely mainly on facts. I must compliment Senator Tate for the way she dealt with the facts. But I heard throughout the speech about 10 times, I am told. Nothing to support it. But I am told, sir, that the Honorable Senator will soon be removed from this chamber. But I will not say so because I'm told. It is not a fact. No. But you're not the opposition senator. But the thing is, sir, that I remember, sir, I would wish to continue, sir. I remember as far back as 2018, when the then Attorney General was challenged about not doing enough for crime, or to address the crime situation. The issue was that nothing was done to assist the police to carry out their duties. Police did not have cars, or proper cars. They didn't have proper guns, as was mentioned. They didn't have proper of anything. And that was a contention. You're not equipping the police to deal with these matters. Fast forward to this year's budget. $145 million was budgeted for the police force. Compare that with 111, even give you more than you had. $111 million up to 2018. But yet we have the goal, if that's the parliamentary word, sir, to come in here and talk about they don't have cars and cars should be upgraded every 3 years. With some of the latest cars I see the police have. Nobody told the Honorable Senator that. Sir, there's something that bothers me as well. That in a debate about police, you go back to talk about housing and hurricanes. And most of the speech was taken up on that, housing and hurricanes. Then we have people in this country who have not yet had their houses fixed since Thomas. We have the goal to come and talk about these things and creating a fear in the hearts of Barbadians about all of these things. There's one other thing I can talk about, but I don't want to talk too long. So I normally rely on one of my disciplines when it comes to these things. In 1834, when, and I hope that we soon change the 1st of August from celebration of emancipation, but in 1834, the planters in the Caribbean were given $20 million in compensation. Today, that is worth I think it's 18 million or something like that. So much so that the British government only recently stopped paying it back. 2015. It was worth trillions. So what you're saying is that the value of money, even though it was almost devalued before 2018, but the value of money keeps increasing. So therefore, you cannot now come and say that we taking we are increasing things from $5,000 to $10,000. We are talking $5,000 in 1975 with a law that was passed under the Democratic Labour Party. But you are coming here to make this country feel, not only driving fear, but make this country feel that that the Democratic Labour Party has the answer to every solution, to every problem in this country when they didn't have it. I'm concerned so that you're making it seem as though that because fines are increased, because the Prime Minister says, and they understand her to have said, that there are certain things they shouldn't lock up people for. Because if you suppose you have to lock up people for talking without producing the facts. So, you know, sir, the vacuity in his brain is so excessive that he constantly seems to interrupt me. You know what I'm saying? But I would not go any further than that. I think so that when we come to this assembly, that we need to, rather than try to drive fear, because that's what all I'm see going on, fear in this country. We talk about the police and we want more people, but have you looked at the reduction in the numbers going into the police force in terms of our reduction in population? Have you looked at it and see in terms of the lowest unemployment rate ever in this country, or the second lowest? These are relational things that you have to put together. But to come in here every minute, you are told, and yet it's untold foolishness, sir, if that's parliamentary. We cannot, this is a serious place. We rely on facts. And we need to stop trying to drive fear in this population, because that's what the intention is. I have always quoted from Ecclesiasticus, something that Friar Montesinos preached on Whit Sunday in 1511 in the Cathedral of Santo Domingo. He that sacrificeth of a thing wrongfully gotten, his offering is ridiculous, and the gifts of unjust men are not accepted. I believe, sir, that it is time that we deal with the facts. And we should try our very best not to drive fear in this population. Because someday, I mean, it may be a long, long time from now, you may have to come to lead this country. I thank you, sir.
Thank you very much, Senator Reverend Morris. Senator Kevin Boyce.
Thank you, Mr. President, and I recognize the state of play. Sir, my contribution, coming on the heels of the previous speakers, as always, would attempt to collide with the legislation. Objects and reasons being stated, sir, A, B, and C. Police Act, Cap 167, sir, and the objects of reasons of this bill, unless the amended version says something different. It says as A, to provide for special constables, we heard about that. B, bring the language of the act into conformity with the Constitution, we heard about that. Provide for matters in relation to A and B. Sir, in the course of my attempt to get rest last night, I was encouraged to look at Section 26, which is the section which was spoken about by the Attorney General in the other place. And it is the section which deals with assistance from the Barbados Defense Force. In the other place, the indication given was that you needed the amendment to the legislation so as to give protection to the members of the Defense Force who assist the police when they're doing the joint patrols. Sir, I believe it is accepted by all of us in Barbados that we appreciate having the Defense Force there to bolster the police in their duties. I think that goes without saying. I do remember as a youngster the song Boots and why it was popular, and I think it was a very good anecdote that was told earlier in this place that we moved from a place of fear to the soldiers being a part of the festival as such. What is interesting though, sir, is that the new section 7A says that a member of the Defense Force who is deployed to the police service, my understanding is that Defense Force cannot be deployed to a police service, but can certainly assist the police service. That's the first thing, sir. Secondly, pursuant to directions given under Section 9.2 of the Defense Act. Now, sir, Section 9.2 of the Defense Act indicates that the Defense Force acts under the Governor General / President, and if there are no such instructions or no such directions from the Prime Minister. My understanding, sir, is that these directions as such guide the operation, and I wish to read it, sir, because it is relevant. Section 9.2 of the Defense Act says the Chief of Staff of the Barbados Defense Force is subject to the directions of the Governor General / President, responsible for the operational use of the force, but the Prime Minister may, where no directions have been given by the Governor General, give to the Chief of Staff directions with respect to the operational use of the Barbados Defense Force in Barbados for the purposes of maintaining and securing public order and public safety as the Prime Minister thinks fit, and the Chief of Staff shall comply with those directions. Sir, it then goes on and says, for the purpose of maintaining, securing public order and public safety, shall be granted the powers, authorities, privileges, responsibilities, and immunities of a member of the police service under Section 19, and shall provide the duties and shall perform the duties thereof for the period specified in the directions. So firstly, directions with regard to the deployment, sir. The wording is going to cause some issues, sir. Secondly, the powers that are listed in Section 19 are powers which the police have for the conduct of their duty. And I wonder, sir, if the intention of Parliament is to say that while we appreciate and recognize the assistance that is needed for the Defense Force to bolster the police when conducting their duties, and the example being given of crop over or special operations, as this is currently worded, it requires that the Defense Force, sorry, it doesn't require, sorry. Let me bring up the Police Act, sir. It says that our soldiers, for the period of deployment, now have the powers which the police have. And it's not just the power of arrest, which I'm going to come back to, sir. Under Section 19, it says, these are the following powers that are set out under the Police Act. Sir, the power to preserve peace, no issue, but to prevent and detect crime and other contraventions of the law, to apprehend and bring before a magistrate persons found committing an offense, to charge or to cause to be charged before a magistrate and to prosecute persons, to serve and execute at any time, including Sundays, all warrants, to keep orders in the precincts, to repress internal disturbances, to defend Barbados against external aggression, and generally to do all duties appertaining to the office of a constable. These powers are quite wide, and I'm wondering if that is the intention of the government and the Parliament in this instance. Secondly, sir, I have had experience in my first job as such, as a lawyer, working on a commission of inquiry into a riot in the prisons in Jamaica, in Spanish Town. And I was working with the Jamaican Defense Force. The issue was that there was a riot in the prisons because there was a strike and they needed to bring someone in to deal with the prisoners, so they brought in the Jamaican Defense Force. As a result of the Defense Force interacting with the inmates, and so as not to cause any further issues, there had to be an inquiry, a commission of inquiry into the resulting situation, which I can describe as an alleged attempted execution of prisoners, allegedly by members of the Defense Force, which was stopped by a chaplain, actually, allegedly. And that experience, sir, gave me a tremendous understanding for the difficulties, because while working for the Jamaican Defense Force, you recognize the hardships that they are dealing with, and you're hearing the stories that their lives under threat, they're being killed on patrol. It's a different mindset. And we have heard echoes of that in our society, where persons say that our soldiers are not trained to police. And assumingly, maybe they will be trained, but it is a different mindset, I understand, by persons who serve in that defensive capacity. I say all that to say, sir, that as worded, it is a wide power that's given, and there have been other jurisdictions in which one, because we don't follow other jurisdictions in the Caribbean, sometimes we do, but we don't, where the attempt to give soldiers powers of arrest in 2013 was refused. That required a constitutional amendment. In 2018 in St. Kitts, soldiers were deployed to support the police and were sworn in as special constables for the purpose, because they had a shortage. That was the Prime Minister, Timothy Harris. In this circumstance, in an attempt to assist Is it that the powers that are being granted, which are only subject to the period specified in the directions? I've made inquiries of certain JAG officers overseas, and they've indicated to me, well, there normally is a period for directions. There normally is, but we don't know because it says subject to that. So it is an issue which I don't believe it has been ventilated much. It was referenced, and example was given about crop over, but there are other languages, there's utilization. I've seen reference that you give the defense force the power to detain until a member of the police arrives who will do the arresting. You give the defense force the power and protection from being sued for murder or anything of the sort which they're doing in their duty while still preserving the police for the police. Because right now it works for the Coast Guard, but what does the Coast Guard have to do? When they get the person on land, they immediately have to deal with the police in terms of the handover, and there are no police on the sea. So, sir, that's my initial contribution on that, and I assume the government will respond and address all these concerns. Second point, sir, I would be in trouble with my cousins. I like to refer to my group chats, and as usual, in doing my anecdotal compare, contrast, and ask for consideration, the concept of assisting police came up. And we, as the lawyers, know it goes back for common law, and I've heard Senator Nichols say, we don't worry about our common law, we got our own common law, but it's convenient to have our utilization of the ancient common law in this case, and it's part of our legislation, which says that if a police officer says, assist me to apprehend, or assist me, I'm holding some hand here, come in here and help me, you are obliged, and it's an old principle that you have to assist the police. The concept of that is something which I believe, if you remember my earlier contribution today, sir, the messaging needs to be out there and explain that it's hardly a charge that is brought up. I found a case from 1841, R versus Brown, where it came up. I haven't found any Caribbean authorities. I haven't looked that hard for them, but I assume they exist. But it's one which it is hardly utilized because it's one of those things which, well, could there. Secondly, sir, the indication of what that means for a citizen, and I believe that Senator Tate has addressed the concerns, is one that, again, shouldn't be poo-pooed. It's a serious consideration. We have sat here and said, crime is bad. We have sat here and said, we need witness anonymous techniques. So if the witness get to be protected, we're still saying, but if you don't help the police, who has a gun or whatever else, you have to pay a fine of $10,000 or $20,000. So you have to understand that that may cause some people to say, but what's going on? The police got the gun, the police got the form, the witness got the special thing, despite the issue with the forms. But what about me? So these are the type of questions which I would encourage the government in terms of the messaging and being the one responsible. And the opposition has raised them, and they are objectively valid concerns that people, and it's to say that you did it first, come on, man, we passed that. But remember, politics is personal. Secondly, sir, under section, that is section 62, I think that was, which one is the assistance? So the assistance is, sorry, that was section 65. No, that's section 68, so that's refusing to assist. So again, maybe some assurances from the hey, we're not going to be doing this, the policy of the government is not to do this, maybe that will give some comfort, but you understand why it arises as an issue, given all the fears that we have expressed about crime. In terms of the increase of fine for assaulting or obstructing a member of the service, I don't think there's any issue with that. Now, the aids or incites any person to assault, obstruct, or resist, again, a little tricky, but we understand that. Now, the use of abusing or insulting language. One of my first cases, apparently a story time tonight, sorry. One of my first cases involved the Public Order Act, where the concept of using language that is likely to cause a riot or a fray. It's one of those fun cases. I had a lovely client who used such a beautiful, colloquial abusing that when I heard it on the video, I said, well, this is like Shakespearean. But the concept of saying that if you use abusive or insultive language, while we are saying that people should be able to do certain things, it is one of those, I would suggest, ticklish situations, but it is on the books. It has always been there. The question is, fine up to $20,000. We understand as lawyers that it could be up to, and that $20,000 is the maximum, but again, the messaging that the people are hearing out there because of whoever is that is a $20,000 fine, because that is what it says. On conviction to a fine of $20,000 or to imprisonment for 2 years. Now we know that is up to, or it's alternative, but the people out there do not know, and the messaging has to be pointed. The government is the one responsible for the messaging that the people get. Finally, sir, there is a section that carries over from the other legislation, the older legislation, sir. And that's section 49, which restricts the members of the service from engaging in private business or trade without the consent of the president. The consent referred to in section 1 shall be a writing and signed by the commissioner. So we have already had discussions about the pay levels. That's been spoken about. We already spoken about the increase in cost of living. That's been discussed. We know that police sometimes moonlight doing other jobs. We recognize, however, that police cannot be carte blanche in doing other things while they have their duty, but it is one of those things where the restriction as such, does it need to be at the level of consent from the president? Can it be perhaps be given at a lower level of station sergeant for a limited amount of hours to allow someone to supplement their income? Especially in the context of how things are, and as the young people, as set out by Senator Trim, we are now in the age of the gig economy where everyone has a side hustle, even the lawyers, sir. You're doing a lot of things on the side. Yes, sir. Also, sir, when that is combined with the increased penalty for someone who has left the force and the removal of the benefits and the gratuities, you recognize that there's a bit of a burden, a heavy burden in these circumstances. And what I'm referring to there, sir, is section 49 when also considered with section 65 in terms of causing dissatisfaction. So you have a situation where we've spoken about persons having to leave the force for whatever reason, we've spoken about the cost of living, but the penalty goes up for someone who has caused dissatisfaction in relation to the service or the force or for whatever reason, disaffection, thank you. And if you're guilty of the offense, it goes up. So these penalties for those same brave men and women who we're relying on should be considered, or at least definitely be brought home for their understanding and appreciation. So, sir, these are the points I've raised. I trust they will be addressed, and I thank you for your indulgence.
Thank you very much, Senator Kevin Ross. Senator Cummings.
Thank you very much, Mr. President. Excuse me, I want to acknowledge the honorable senators who have spoken. I acknowledge the comments which have been made. I want to draw the honorable senators' attention to a slew of interventions that the Honorable Attorney General has made on the various interventions as it relates to the Barbados Police Service. I want to also respond to the query justifiably raised about concerns with payments by police. I believe that we have seen that even at the level of the Attorney General, he has shared those concerns. He's not an accounting officer, but he has undertaken to meet with his administrators and accounting team, excuse me, along with the special constables to be able to address the concerns that have been raised by the police service, have been raised in the public domain, And I'm certain once they were brought to his attention by the members of the police service, that they were raised also by him. I give that assurance. There were a number of comments that were raised in terms of the coordination of this existing piece of legislation, and I simultaneously was engaging with the Office of the Chief Parliamentary Counsel, who has been following the debate live alongside with us and sharing her feedback. She's indicated that there are, on a couple of occasions, where in the 2020 amendments of the Police Act, quite a few of the items which were raised were actually addressed. They are not all addressed in that 2020 amendment, and as such, they have heard and they will be reverting in due course, having taken into consideration the comments which have been made. And so, Mr. President, having thanked the honourable senators, I beg to move at this time that this bill be read a second time.
The question is that this bill be read a second time. Those honourable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that you do not leave the chair and the Senate resolves itself into committee for further deliberation on this bill.
The question is that I do not leave the chair and the Honourable Senate resolve itself into committee for further consideration of this bill. Those honourable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
The Honourable Senate is now in committee.
Mr. Chairman, permission to call in groups of clauses.
Granted.
Clauses 1 to 15.
Mr. Chair, I beg to move that clauses 1 through 15 do not stand part.
The question is that clauses 1 to 15 will now stand part. Will all honourable members in favour please say aye? Aye. Those against, please say no. The ayes have it.
Clauses 16 to 32.
Mr. Chair, I beg to move that clauses 16 to 32 do not stand part.
The question is that clauses 16 through 32 do now stand part. Will all those honourable senators in favour please say aye? Aye. Those against, please say no. Methinks the ayes have it.
First schedule.
Mr. Chair, I beg to move that the first schedule be the first schedule to the bill.
The question is that the first schedule be the first schedule to the bill. Will all those honourable senators in favour please say aye? Those against, please say no. Methinks the ayes have it.
Second schedule.
Mr. Chair, I beg to move that the second schedule be the second schedule to the bill.
The question is that the second schedule be the second schedule to the bill. Will all those honourable senators in favour please say aye? Aye. Those against, please say no. Methinks the ayes have it.
Mr. Chair, I beg to move that you do not report to His Honour the President the passing of one bill in committee.
The question is that I do now report to His Honour the President the passing of one bill in committee. Will all those honourable senators in favour please say aye? Aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported the passing of one bill in committee.
Mr. President, I beg to move that this bill not be read a third time.
The question is that this bill be read a third time. Those honourable senators in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do not pass and be cited as the Police Amendment Act 2025.
The question is that this bill do not pass and be cited as the Police Amendment Act of 2025. Will those honourable senators in favour please say aye? Those against, please say no. Methinks the ayes have it. This bill is now passed and so cited.
Mr. President, revert to reports from select committees.
Reports from select committees. And I've two reports. Reports, first of all, from the selection committee.
No, standing orders. Standing orders first.
Standing orders, okay. Go with standing orders first. The committee comprising myself as chair, Senator Cummins, Senator Paris, Senator Kevin Boyce, Senator Worrell, met on Wednesday, August 20th, 2025 to consider an amendment to Standing Order 6TA3 to increase the membership of the Senate on the Joint Select Committee's standing from 3 to 4, consequent on the amendment by the Honourable the House of Assembly with respect to the composition to the membership of committees. The committee agreed to the proposed amendment to the standing orders of the Senate, and Standing Order 60A3 reads as follows. Each committee shall consist of 9 members from both houses of Parliament, of whom 4 shall be from the Honourable the Senate. 4 members shall constitute a quorum. The committee is therefore pleased to present the amendment as that worthy of consideration, of commendation, and supports the adoption by the Honourable the Senate. We're asking for the Honourable the Senate to approve this amendment to our standing orders. This is to make it consistent with that of the House of Assembly, increasing the overall membership. So we have one more, they have another, and it's ready to regularize that so that the work of the joint select committees, the standing committees, can proceed. Is there any objection? Those in favour? Those against? The report is adopted. Selection. The next report is from the Committee of Selection, which met today, 20th of August. President were myself, as chair, Senator Cummins, Senator Kevin Boyce, Senator Worrell. Now, the committee met to consider nominations for membership and for the proper constitution of the committees of the Senate and the Joint Select Committees standing due to vacancies therein. This committee considered and made the following nominations for appointment to the committee set out here under. And essentially, this was consequential on the move of former Senator Chad Blackman to the House of Assembly, and the appointment of Senator Reid, and subsequent to that, then, Reid in favour of Dr. Haynes and Senator Trim because of the movement of Senator Blackman. So a few adjustments, not major adjustments. Essentially, therefore, the committee considered and made the following nominations for appointment to committees as set out. Committee of Selection, Senator Most Honourable Jerome Walker. House Committee, Senator Ms. Paris. Public Accounts Committee, Senator Dr. the Honourable Chantal Monroe Knight. And then in relation to the expansion of the standing committees, which was approved just moments ago, the individuals there will be Committee on Governance and Policy Matters, Senator Kevin Boyce. Committee on Economic and Productive Sectors, Senator the Honourable Jonathan Reid and Governance and Policy, Senator Andreli Boyce. Committee on Economics and Productive Sectors, Senator the Honorable Jonathan Reed and Senator Roshana Trim, and Committee on Social Sector and the Environment, Senator Roshana Trim. These proposals are put forward by the Committee of Selection for the approbation of the Honorable Senate. Those in favor of adopting these recommendations? The Honorable Senate is asked to adopt this report, and on doing that, then these appointments take effect. Those in favor? Aye. Those against? Report is adopted. Congratulations, and thank you for serving, honorable members, on those respective committees. Just an important note of procedural information. Please note that the amendments which have been made to any of the bills which were before us will require us to encapsulate them into a note which will be sent from me to the House of Assembly on their behalf to indicate what amendments have been made here. And that procedural matter will be followed. Senator Cummins.
I think we've waited for this for a long time. And so I rise to thank all honorable senators who have stayed the course from 10 o'clock this morning, from 11 o'clock this morning until almost, well past 10 o'clock, almost 11 o'clock tonight. And so with those few words, Mr. President, I want to close by acknowledging Senator Trim's maiden contribution in a seminal debate. Welcome, Senator Trim. You have already established yourself in this space, and I therefore beg to move that, having come to the end of government's business for today, finally, that the Senate now be adjourned sine die.
The question is that the Honorable Senate do now adjourn sine die. Will those honorable senators in favor please say aye? Aye. Some of us are very enthusiastic. Those against please say no. Methinks the ayes have it. Thank you all for an extended day and great debate, great work. The Senate stands adjourned.